rights, norms, and standards, more so when Fiji is a state party to all 9 core international human rights treaties and conventions. And in addition to these 9 core international human rights treaties and conventions, it signed in 1998 the ILO Convention 169, which is the Convention on Indigenous Peoples and Tribal People, Indigenous and Tribal Peoples Convention. And early this year, Cabinet officially endorsed the United Nations Declaration on the Rights of Indigenous Peoples. So as a state...
Just pause there. I'm interested to hear that. Fiji is presumably one of the first Pacific countries to endorse the UN Declaration.
That is correct, my lord.
And so I think of around, is it 10 Pacific jurisdictions, all with majority Indigenous populations? Fiji is the only one so far to endorse it.
I'm not sure about the other Pacific jurisdiction, my lord, but I can say for Fiji, we have. So as a state party, Fiji has binding international legal obligations to respect, protect, promote, and fulfill the human rights enshrined in these treaties, and to ensure that they are an essential component of its national laws, its governance, its policies, and its practices. Our intervention makes particular focus on the individual human right of self-determination and also on the group right to self-determination in relation to indigenous peoples and their right to give free, prior, and informed consent. The question of whether or not the people of Fiji were consulted before the establishment of each constitution raises the right to participation. Article 25 of the International Covenant on Civil and Political Rights says that everyone has the right to participate in decisions which affect their human rights, including the right to participate in public affairs. So obviously, that would include the right to participate in negotiations and makings of constitution, to vote and have access to public services. Participation must be active, it must be free, it must be meaningful, must be accessible, including access to information in a form and language that can be understood by the people. On the right to participation, the Commission in its assessment, it went back to the 1970, the 1990, the 1997, and the 2013 constitutions, and we concluded that the 1997 constitution was the one most widely consulted under the work of the Reeves Commission. It was active, free, meaningful, and accessible to the people of Fiji, and therefore reflected the will of the people of Fiji. Now, the 2013 Constitution, our conclusion was that there was no substantial evidence to confirm that active, accessible, genuine, and meaningful consultations were carried out with the people of Fiji. So we concluded that the 1997 Constitution was imposed and did not embody the will and sovereignty of the people. So on the 5 reference questions, your lordships and your ladyship, our submissions carry the detail, so I will simply just go through and just mention some critical aspects in relation to our arguments. So the first question on question 1.5a, whether the provisions of Chapter 11 and Part D of Chapter 12 of the 2013 Constitution of Fiji are binding in a way that makes them permanently unamendable, regardless of Parliament or public will. The position of the Commission is that it agrees generally with the position the state has taken, that these provisions are not absolutely binding and can be amended, though the current process makes it extremely difficult to do so. So our key arguments are: 1, legal framework and parliamentary sovereignty. Sections 159 and 160 of the Constitution impose a double entrenchment. 75% support in Parliament at second and third readings, 75% of all registered voters in a national referendum. Not just those who vote, and here there is an ambiguity, and we are still going back and forth as to what that phrase really means in terms of the registered voters and the registered voters in Fiji. So we tried to work out, does this really mean 75% of those who come and vote, and you take the 75% from those who actually did the voting, or those who come and vote, and then you work out the math by looking at the register and finding out whether it constitutes 75% of what is in the register. So when we read the amicus submission on better meaning, we felt that we would go with his interpretation in relation to better meaning, because in our assessment, the better meaning that he proposes facilitates the rights of the people. So our argument number 2, democratic concerns. The Constitution has been referred to as, double quotes here, unamendable due to the impractical threshold. No prior referendum or inclusive process occurred in 2013. Public consent was not obtained, violating democratic principles and the right to self-determination. Argument 3, violation of international human rights standards. The provisions are inconsistent with Article 1 on the right to self-determination in the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. Fiji ratified these 2 covenants on the 16th August 2018. It's also inconsistent with Article 21 on the United Declarations on Human Rights, and also inconsistent with Article 25 on the International Covenant on Civil and Political Rights. So Fiji, as a state party, must align domestic laws with these obligations. Entrenchment provisions hinder the people's ability to reform governance, undermining meaningful participation. Our argument 4, Indigenous rights and governance structures. The 2013 removed the Great Council of Chiefs, thereby undermining and weakening Indigenous representation. And I must add, your lordships and your ladyship, the manner in which they did this in the public space was indeed very humiliating. And it really hurt a lot of the Indigenous people, and I must say I am an Indigenous person. So I understand the feeling of humiliation in the manner in which they were removed very publicly, but I'm pleased to say that they're back. They were revived and resuscitated, and so the resurrection happened sometime this year, I believe, but I could be wrong on that. But they're back in the public domain, and they're very vocal. And I should also add that the dominant population in Fiji is the Indigenous population. So it's very important that sensitivity in relation to their rights are actively addressed. On the acquiescence argument, we felt that this needs to be re-examined. The participation in the 2014, 2018, and 2022 elections under the 2013 Constitution does not necessarily imply acceptance of the Constitution itself, because in our view, from what we, on the research and also because I lived through all of this. So I can say with some measure of confidence that the political parties saw elections as the only pathway to restore democracy, not so much as an endorsement of the Constitution. And this is why in our written submissions, we called it was an acquiescence under duress for the necessary purpose of restoring democracy, because if they did not go that way, the other alternative was for this military regime to continue on the repressive.
Just pause there. I understand that, but Prasad talks about endorsement by elections, and it would be talking, I think, about endorsement generally by elections of this kind, not perfect democratic processes, but elections where parties can compete and where there is a risk that the governing party will lose, as indeed happened. So what do you say about that? I mean, if you look through the Prasad guidelines, this does look like quite a strong case for validation or recognition of the 2013 Constitution.
Yeah, my response to that, my lord, is that what happened at the time was that the military regime, they did not implement a best practice. They remain on in power. So they oversaw even the election process itself. So in a way, it almost guaranteed that they became the elected government.
But it didn't at the last election, though. It didn't at the last election.
The last election, they were the party with the most votes.
Yes, I know that, but they lost power. And I mean, I've found it a little difficult to locate some of the reports on it. So there's a multinational observer group that reported, I understand, on all elections, but I could only find their report for the 2014 election. Are those reports available?
From what I gather generally, I have not seen the details of their report. It has been labeled as credible. So I'm not quite sure what was the measurement that they used.
Well, the one in 2014 regarded as a credible election with a result reflecting basically what they saw as the will of the electors. And what I've read of secondary material suggests that the same was true of the 2018 election. I'm not sure, I don't think I've seen commentary about the next one.
I think there is a report on the 2022 election which compared it favourably with the 2014 and 2018 election and then made some recommendations, but generally a more favourable perspective than the other two. It may have been attached to the Electoral Office report for that election.
Right. Okay.
Thank you, my lord. Shall I continue on, or do you expect
Yes,
me
no,
to...
carry on. That was really the point I wanted to discuss with you, and I've been helped by the judge's comments as to where I might find it.
So can I just continue on? So if I may, while I understand the opinions, your lords, and what you say in terms of the elections and the credibility of it, for someone who's lived here and experienced what is happening, even the credibility, I would not give it ringing endorsement. But anyway, so the electoral participation occurred under duress with continued dominance of the coup era and the military regime and the officials and institutions. So the de facto, the military government that came did not give over to a caretaker government. They won. It seemed as if that was going to be a logical result because they designed and structured the political and electoral system and had more than just an influence. So our conclusion is that the Commission concludes that the entrenchment clauses are not truly unamendable, but are undemocratically rigid. They undermine parliamentary and popular sovereignty. They breach international obligations on self-determination and human rights, were established without public legitimacy or proper, meaningful, and inclusive participation. So we say that these provisions should be reconsidered to ensure the Constitution is amendable, democratic, and reflective of the people's will, and care should be taken to respectfully address and include Indigenous Fijians and their voices. On question 2.5b, can the provisions referred to in 5A, specifically Chapter 11 and Part D of Chapter 12 of the 2013 Constitution, be amended through a bill enacted by Parliament in terms it deems fit. The Commission agrees that Parliament can amend these provisions through a bill, provided and on condition that the terms of amendment align with international human rights standards and democratic principles. However, the current procedural requirements in sections 159 and 160, in our opinion, are overly rigid, undemocratic, and so we think it really requires your lordships and your ladyships, your judicial goodwill, grace, and intervention, that they be rendered invalid or revised. Our key arguments are, 1, the legitimacy of sections 159 and 160. These amendment provisions were imposed without genuine public consultation. They originate from an undemocratic process under a military regime. The provisions violate the principle of self-determination and popular sovereignty and thus lack democratic legitimacy. Number 2, constitutional interpretation. Sections 159 and 160 should be interpreted in light of Section 3.1, which mandates a reading that promotes democracy, dignity, equality, the underlying values that underlie a democratic society. So what we would advise here is a purposive approach, that the Supreme Court adopts a contextual and purposive approach, not a narrow or literal one. And we had advised that the living constitutionalism approach, that the Supreme Court treats the Constitution as a living organism that needs to evolve with society, and that sections 159 and 160 must be adaptable to meet contemporary needs and values. Number 4, our argument to number 4, limits on parliamentary power. While Parliament holds general legislative authority under Section 46, it is bound by specific amendment procedures in sections 159 and 160. Therefore, Parliament may not always act, quote that phrase, in terms thought fit, without judicial clarification on these constraints. Argument number 5, judicial invalidation of entrenched clauses. The Commission argues that the court could invalidate or reinterpret sections 159 and 160 because they, 1, violate democratic values, 2, were imposed without consent, 3, are inconsistent with international human rights obligations, and 4, undermine the Constitution's own foundational principles from sections 1 to 3. And our 6th argument is the alternative mechanism, a national referendum. The Commission proposes a non-binding national referendum to test public support for a more amendable provisions. Such a referendum could guide Parliament in enacting a new legitimate amendment process. The referendum, in our view, should simply require a simple majority of actual votes cast at the referendum rather than 75% of registered voters in Fiji. And as I've said, your lordships and your ladyship, we're still trying to understand what that phrase really means. Our conclusion is that Parliament may enact a bill to amend the entrenched provisions, but not in any terms it wishes, as it must, 1, respect international obligations, in particular its human rights obligations, conform with democratic principles and the rule of law, seek judicial clarification, or invalidate existing amendment rules and consider a national referendum as a more democratic and inclusive path to constitutional reform. So the Commission urges the Supreme Court to interpret sections 159 and 160 through the lens of living constitutionalism, treat the Constitution as a living organism, and advise government to pursue mechanisms rooted in popular sovereignty and human rights to ensure the Constitution is amendable, legitimate, and fit for purpose for a democratic Fiji.
Would it be right to say that your minimum position is that you want from us an opinion which would lead to a more readily amendable constitution, which could then, through a process of amendment, address some of the issues that you have raised, whether they be Indigenous interests or human rights issues and so forth. But you wouldn't expect us, would you, to set out prescriptions on what arrangements should be made in respect of Indigenous interests, or particularly how human rights should be recognised, respected?
I agree, my lord.
Yeah.
May I move on? On question 3, is approval of an amendment under Section 5B effective only if approved by the people of Fiji at a referendum? So the Commission, we continue to question the rigidity and legitimacy of this requirement as it is stated, because of the problem we have in terms of the 75% concerning the registered voters in Fiji and 75% of the registered voters, which amicus proposes as a better meaning. We went, as I've already said, along with that better meaning. But our key arguments on this is that having assessed everything, we thought that from the Human Rights Commission, we can only go and support a pathway where human rights is strengthened and protected. We cannot support any pathway where human rights would be endangered, threatened, violated, or suspended. So this is why, having weighed everything, we felt that the way that would protect the human rights of a great majority of people in this country is to work with the 2013 Constitution. We also propose an alternative to a referendum, and that is a constituent citizens' assembly. Now, when we propose these mechanisms, we are saying that they are only consultative. Whatever decision they come with is not to be legally binding, just a gauge to measure the people's will and their mood concerning particular issues. So we say if a referendum is not the way to go, perhaps another mechanism could be considered, a constituent citizens' assembly representative of all Fijian communities and stakeholders.
I can't recall the detail of what was proposed in 2012, but does that provide a template or a blueprint for what you're suggesting?
Yes, the Yesh guy.
No, it was before the Yesh guy report. It was in the decrees that were set up before the Yesh guy Commission reported.
I'm not aware, my lord, whether
there was a decree. There was a Fiji Constitution, Constituent Assembly and Process decree.
I must admit my ignorance, my lord. I'm not aware unless any one of the interveners is aware of that.
That was by appointment, and they realized also the weakness in it. You know, you'll allow the Veiuto program applying again.
So it was not a genuine mechanism then?
That's one of the reasons why a lot of people don't like constituent assembly. It becomes, you know, you can predetermine the membership. So you need to look at something, if you're going to be consistent what you're basically saying, it has to be truly representative of the people who have elected representatives, not just people recycle in so many different ways.
No, that is true, my lord. I'm fully aware that a referendum and also a constituent assembly if the state does not do the proper job of raising public awareness, it can be a manipulative tool for certain political interests or the powers that be. That I'm also aware, which is why I suggested that perhaps it is best that it is not legislatively binding, that it's just a consultative function. My lords and my lady, it took us, we agonize over this because we have seen how the doctrine of necessity functioned here in Fiji. Here it was those who created, and I think my learned friend from the People's Alliance used the word, they manufactured the crisis, and then the doctrine of necessity was then used more for their protection and to entrench them in power, and so on.
I think the doctrine of necessity is used in at least two respects. One is to justify a apparently extra-constitutional intervention, and then secondly, in a different sense, the role of the courts in making sense of what's happened, where by reason of necessity, there being only one government in office, the courts have tended to recognise the official actions of that government. So I don't think that you created the emergency, therefore you can't rely on necessity, actually captures the issue in relation to recognition of government actions.
Thank you, my lord. We would go with the second one. I was just trying to express the experience of how it functioned here in Fiji. We've had 4 coups. The 3 that were successful were all military coups because they had public assets they could use against their own people. The one that failed was a civilian coup because the military abandoned them somewhere along the process. But that's what I'm saying, which is why we agonized over this concept of necessity. But we felt that the Supreme Court, in its wisdom, we used the Cypriot issue. We've read amicus advice against that because we see that one of the difference between, apart just from the conditions itself, that the Cypriot Supreme Court read necessity as implicit in its own constitution, but they were able to make certain amendments to the constitution using necessity. Because it was implicit, they read it as implicit in the Constitution, it was not considered an extra constitutional measure. I am not in a position to say whether the necessity is implicit in the 2013 Constitution, but that is something, I think it's more in your area of expertise, my lords and ladyship. But we just left it there as a possibility. If there is no other solution, perhaps necessity can be used where once those who began a revolution and use it for their own consolidation of power and to entrench themselves in power, that maybe this is the Supreme Court using necessity and contextualizing it could perhaps use it in a way to work in the people's interest. Our critique of sections 159 and 160, we say that it is too rigid and undemocratic. It frustrates Parliament's attempts, which has already happened. They only, Sonia and Ed so far, they only managed to get 1 vote. But I think we need also to understand the political dynamics because Fiji First as a party died, and so some of the members that used to be at Fiji First has gone across to government, so they were able to build up the numbers. But if you really just look at it, if they just remained in opposition, it would be the former government in opposition. It would be very, very difficult. Forget about the 75%, even to get the 66%, the 2/3. I'm just saying that, Your Lordship, if you just bear with me, it's just for someone who understands the political dynamics, it's not only that 75% would be very difficult, it's also 66 and 2/3%.
But shouldn't it be, I mean, if you take away for the moment objections to some of the content of the 2013 Constitution, isn't it right that it should be a bit difficult to amend it? I mean, most amendment provisions in constitutions require supermajorities, normally at 66%, sometimes 75%. So don't we have to look at this in terms of the long run, not just the current political situation in Fiji?
Yeah, that is correct, my lord. So that's why we, in our detailed written submissions, we had said that we probably need a group of experts, of constitutional experts, to have the eye of an expert and look comprehensively at the sections and come up which issues require a simple majority, which issues would require 62/3, and which issue would require 75%. I understand the argument that some issues are so foundational that it binds successive parliament. But there's also the argument is how is it that a form of parliament basically disrobes the power of another parliament that is, who finds it very unable to change the constitution to make it responsive to the generation that they govern. So you have these two arguments,
Right.
my lord. On the role of the current government, your lordships and your ladyship, the current coalition government has taken steps toward democratic reform, including repealing restrictive laws, restoring the Great Council of Chiefs, and establishing a Truth and Reconciliation Commission. I mention this because these show momentum towards constitutional responsiveness and increased public participation. And of course, they tried to amend the Constitution. They could not do it politically, so they resorted to coming to you, your lordships and your ladyship, to help them. And from the Human Rights Commission, the judiciary is a vital institution helping Parliament. And of course, there are other critical institutions of the state as well to facilitate and effectively implement the people's will. We looked at the Venice Commission, and we see that the amicus has done quite a bit of work on the Venice Commission, but we just want to say that there was a conclusion that the Venice Commission made, and it was that absolute entrenchment can prolong conflict, destabilize governance, and eventually must give way to reform when political and social pressures demand it. So our conclusion on this question is that while the 2013 Constitution requires a referendum for certain amendments, the Commission recommends alternative, more flexible mechanisms, such as the Citizens' Assembly, or, and we say this with great concern, a little bit of fear, invoking the doctrine of necessity. These approaches, we think, aim to make the Constitution more adaptive, participatory, and aligned with human rights and democratic principles. On question 4, is a special majority required for the enactment of amendments under question 5B or for approval under 5C? If so, what proportion of majority is required? So our position is that we need to balance rigidity and flexibility in constitutional amendments. The Commission submits that a balance must be struck between a constitution that is too rigid, like the current 2013 Constitution, and one that is too easily amendable. And a number of interveners have already expressed their concerns if the Constitution becomes too easily amendable, because both can undermine core democratic and human rights protections. So we're asking for an amendment process that maintains constitutional stability while allowing for necessary democratic reform and evolution. In relation to the doctrine of necessity and the Constitutional Advisory Committee, the Supreme Court may consider whether the doctrine of necessity can justify amending sections 159 and 160 through legislation, bypassing the entrenched thresholds. And if so, perhaps it may consider advising the government to form a special advisory committee of constitutional experts to, one, determine where a supermajority should apply to protect the entrenched human rights provisions. Because
They probably think they've done that already by applying to us.
thank you, Your Lord. So I'll move on. Thank you, Your Lordship. In relation to the referendum or citizens' assembly, we're just asking for a simple majority of votes cast to gauge what the people think in terms of the amendment. And we think that the requirement, that the double entrenchment requirement, we actually think that they need to go.
So you say a simple majority in Parliament is enough?
No, in the referendum.
No,
or the
I'm going to deal with it at two stages. Deal first with the ultimate decision maker, which
I think
you
we
say
go with a two-thirds, my lord.
you'd go with 2/3. Okay.
Yes. Now, on the resource implications, informally, and I think here it has been raised, that a national referendum or constituent assembly will require significant resources, financial, logistical, public education, etc. But we say that this investment is necessary. We shouldn't be complaining about the costs, because this is to do with the people. It is in a democratic state. The last thing that we should be crying about is the cost. So we think that it's a necessary and an excellent investment in a democratic state to have this, to fund these mechanisms and make sure that they are genuine and not merely performative for certain interests, to restore legitimacy and democratic ownership of the Constitution. So we think it's money well worth spent, and we shouldn't be crying about it. So our conclusion is that the current 75% of registered voters, as is worded in Fiji, requirement is undemocratic, unrealistic, and must be repealed.
What do you say about the immunities, the unamendable immunities?
Yeah, thank you, my lord, for bringing it up. We were trying to hide it, because that was one of our fears, that because the current prime minister and whoever it is that supported him, they're protected under the 1997 Constitution, and they're also protected under the 2013 Constitution. But imagine if the 20 Constitution is thrown out. That's just imagine, that the immunity also goes out. Then you'll have Bainimarama and his men, and I think quite a substantial number of military men up there meaning where they are. They're under the immunity clause. So that's.
So you think it would be unacceptably disruptive, to put it in euphemistic terms, it would be unacceptably disruptive to abrogate the immunities?
No, I didn't say that. I just think that it needs to be addressed in a way that human rights of this country is not endangered, violated, or suspended, because our past experience is that when they come into power, that's the first thing.
Okay, sorry, but I know I'm probably asking something of you don't want to give, but are you suggesting that we should recognise the unamendable nature of the immunities, or we should say that that's unacceptable, it's outside, inconsistent with international law principles like equality before the law, that consequences follow actions and so on? So we could say, well, these aren't acceptable in human rights terms. We've got obligations under the ICPPR. We should not recognise them, or should we say, well, let's be pragmatic about it. We can't have, the Fijians don't want to be looking in the rear vision mirror for the next 20 or 30 years.
I think, my lord, a solution that will be least disruptive, a solution where this country will not experience great economic instability or political instability. I think that's the way to go.
Thank you.
On question 5, is the 1997 Constitution still valid and applicable? I think the question here, 6, question on jurisdiction? I think it's a question on jurisdiction. So from the human rights position, we say that section 91.5 empowers the court to give advisory opinions on the interpretation or application of this constitution. In terms of the scope of the powers of the court, section 98.3 grants the court original jurisdiction over constitutional questions referred to by Cabinet. In terms of its interpretive framework, we think that it should be read together with Section 3.1 of the 2013 Constitution, which requires the court to have a purposive function and interpret constitutional clause in light of its spirit, purpose, and objects, upholding democratic values, the rule of law, and human dignity. I think as well, when listening to the arguments in terms of the opinion, the advisory opinion of the court, I thought that maybe I should say that in Section 17, the freedom of speech, expression, and publication, that every person has the right to freedom of speech, expression, thought, and opinion. And I felt that maybe we need to see that in terms of the Supreme Court addressing this, that opinion and their right to express that opinion is safely and captured in that section. We also felt that John Scott, your lords and your ladyship, if I can just quote what he said of excessive legalism, this is what he said: that strict adherence to legal technicalities and procedures may undermine broader principle of justice and fairness, which may lead to unjust outcomes. Excessive legalism involves an overemphasis on formal legal rules and procedures, often to the detriment of substantive justice. And I believe he said this in the Court of Appeal in the Yambaki case. So our conclusion is that, in our view, the Supreme Court does have jurisdiction to address question 5, because the matter raises profound constitutional, legal, and democratic issues. The validity of the 2013 Constitution is intricately tied to what happened to the 1997 Constitution. So there's no way that you can handle the 2013 Constitution without having to address what happened to the 1997 Constitution. So in resolving it, the court must balance legality, legitimacy, continuity, the sovereign will of the people, and the protection of human rights to safeguard constitutional supremacy and public confidence in the judiciary. My Lord, we have extra 2 questions, but I'm being advised that I have utilized 40 minutes. I will address the memorandum to the parties that we were given during tea time. On question 1, we are invited to respond to the following 2 questions in our closing submission. The power of the court to withhold recognition of a provision of the Constitution as enacted, our answer there, yes, it does have that power to withhold. The power of the court to recognize the Constitution as a whole, but having done so, to treat a provision of the Constitution as enacted as invalid, yes, because I think we've been hearing the phrase of internal contradictions, etc. I think that there's a disease that needs to be removed. There's a little cancer in the body of this living organism that maybe needs to be taken out. And assuming the court considers it has power to qualify its recognition of the amendment provisions, what criteria? Well, we propose whatever criteria the Supreme Court would think of, that criteria must ensure that human rights is not only considered, incorporated, and ensure compliance with Fiji's state party obligation to the International Convention on Human Rights it has ratified. I think, my Lord, I may be losing my time, but we circulated our response to the memorandum dated 14th August. It's about 8 pages, and I think I don't have the time to bore you some more, my Lord.
No question.
I think your time is up.
Thank you, Your Lordship.
Thank you. Right. Maybe we adjourn for lunch. We're humans. We need to have our lunch, and then when we come back, it'll be the Fiji Law Society and Dr. Butt. Yeah. So we'll adjourn for lunch and resume at 2:30.
Thank you.